Alright, we're live. Quitting life. Will's overview. Will's California overview. Since California be tested, that trust recording we just did, that's not simply California, but more general principles. Will's, we're just doing California's overview. Testate estates, execution of wills, attested wills, signature plus two witnesses present at the same time, interested witnesses presumption. What that means is that a witness may not be like a beneficiary, otherwise they very well may not be entitled to benefit under the will. Holographic wills are wills that are written by the testator, and the material provisions are in the testator's handwriting, and they're also signed by the testator. Testamentary capacity is required, which is compromised by undue influence, insane delusion, and fraud. And then there's this like conflict of laws kind of fourth factor under the execution of wills. So moving on, revocation of wills. For a revocation, this occurs by a subsequent will, by a physical act, or by operation of law. Dependent relative revocation, DRR. This cancels a revocation based on mistaken assumption of fact, law, or fact. And it applies where T revokes his will on the mistaken belief that another disposition would be effective, but for the mistake, T would not have revoked his will. And an example is when he strikes through the gift of $50,000 and writes in $100,000 to approach the problem above, organized chronologically. Revocation by a physical act, which is the strike through. Interlineation with the handwritten $100,000. Holographic codicil, since the $100,000 is in handwriting. And DRR, since DRR stands for dependent relative revocation, since the interlineation will fail because it cannot be a valid holographic codicil without a signature. The argument is, but for my mistaken belief that my subsequent devise would be effective, I would not have made the revocation to begin with. Because the subsequent bequest is a higher amount, the court will give the original gift of $50,000, because the court knows that the intent was to give the Benny at least $50,000. The opposite, where in an attested will, the gift is for $50,000 and it's been struck through and reduced to $25,000. The same issues are presented above, but the outcome is different because the DRR, the dependent relative revocation, will not operate to give the Benny any money this time because the amount is lower and the intent was not to give her what was typed, which was $50,000. Therefore, the court will not give the beneficiary anything. All right, so it's funny we just jumped right into there because we didn't even talk really about how there's substantial compliance in California, which I think is like the overarching idea in which the dependent relative revocation falls within. Generally, if a will is lacking on a stipulated component, the court's going to try to revive it by substantial compliance. unless I'm mistaken, maybe it's not written here because it applies to wills and not trusts. I don't know. I'm only reading. Next section is revival after the revocation section. A allows a revoked will to be probated because the revoking will was itself revoked by a physical act. B, to apply Will 1 must still be in existence. The testator must have intent for Will 1 to have effect, and Will 2 must have been revoked by a physical act. And C, to approach the issue organized as follows. 1, revocation, 2, revival. And that's probably referring to how you write about it in an essay. We're in subpart C now, components of wills. It doesn't look like they're going to talk about substantial compliance in this section either. That's sad. We're going to talk about the interpretation section. All right, so for the components of the wills, integration, part 1, integration, says that papers present at execution of the will with intent. And what that means is that you can incorporate papers into a will, but they have to be in existence at the time the will is executed. And I don't exactly know how. I guess the intent has to be like expressed in the will. That's what they mean by papers present at execution of will with intent. Republication by codicil, will speaks at date of codicil. Now, incorporation by reference. Oh, okay, excuse me. Integration. I don't know why I was talking about incorporation. Integration was the first point here. So, in order to integrate papers into the will, they have to be present at the execution, and it really ought to be bound. Now, for incorporation by reference, a whole nother thing, there's 3 requirements: that the writing is in existence at execution, the will shows intent to incorporate, and the writing is sufficiently described in the will. So, whatever document you intend to incorporate by reference is like given an appropriate, like given the accurate title so that it can be identified. And then 4th, acts of independent significance. What that means is that beneficiaries are identified or property by lifetime acts with independent motive. Identify beneficiaries or property. Testator identifies beneficiaries or property by lifetime acts with independent motive. That doesn't help me understand what that's supposed to mean. Independent significance. They didn't really define it in the earlier outline I read either. But I'm going to say we're going to go to subpart D, interpretation of wills. Administration of extrinsic evidence, distinguish patent and latent ambiguity. That's when extrinsic evidence can be admitted. But there needs to be some ambiguity. Either patent or latent. Classification of the gift, there's 4 classes. There's specific, demonstrative, general, and residuary. That's how gifts are classified. Abatement. The order of abatement is based on the classification of the gifts. And it goes in the opposite order. So, if testator dies with $100,000 in their estate, and there's specific gifts, are like, give my wife $100,000, give my kid 1 car, give kid 2 house, but ultimately all of those assets are only $100,000. the way in which the disbursement, the way in which the total estate is abated is in order of what residual. So yeah, and so they would say, and the balance, right? So 100 to my wife, car to the kid 1, house to the kid 2, and the balance to kid 3. Well, there is no balance, so kid 3 residuary is eliminated first. General is eliminated next. Demonstrative, I don't even know. I didn't even learn that one. And specific, everything else is. Okay, I'm wrong. General is the wife's gift of $100,000 in cash. So that's actually going to be abated so that that's the wife's going to get shorted because it goes in order. It shorts the residuary beneficiaries, then the general gift beneficiaries, then the whatever demonstrative gift beneficiaries before the specific gift beneficiaries, and the car and the house, those are specific gifts. So kid 1 ultimately is going to get the car, kid 2 is ultimately going to get the car, kid 3 isn't getting anything because there is no residuary to give them, and then wife is going to get the general gift of monies, but it's going to be reduced by what would have been the car value and the house value. Something like that is what would happen. Actually, I lie. She's just going to get whatever cash is left. Which I was, in my example, I was giving $100,000 in total, including the house and the car, which is why I say if the car was worth $10,000 and the house was worth $20,000, wife gets $70,000, according to this imaginary will I wrote. Redemption. So that's abatement. The order of abatement is based on the classification of gifts. The order is residuary, general, demonstrative, and specific. Redemption, this occurs when a specific gift mentioned in the will is not a part of the testator's estate at his death, because 1, extinction, or 2, satisfaction. So extinction is that this specific gift is no longer owned by the testator at their death. And satisfaction is that a lifetime gift to the beneficiary in writing intended to be a substitute of what that Benny would have gotten by the will. So the will says, I'm giving my son $20,000, but the son needs it while I'm still alive. So I write down on a piece of paper that you're going to get your $20,000 before I die, but that means you're not going to get it by the will. And I'm going to do that in writing because I am too cheap to re-execute a new will or codicil, or I'm afraid to execute a codicil according to the proper formalities. And so I'm just going to write it down and give it to my lawyer. Now, or keep it with my will. Let me see, whatever. So, suggested writing approach. You should have read this. Classify the gift and argue both sides. Is it general? Okay, so when you're writing an essay about this, classify the gift and argue both sides, general or specific. The $20,000 example is general. Step 2, headnote the issue of redemption and IRAC the issue and have 2 conclusions. One for if the device is a general gift and another for when the gift is specific. That's how you deal with redemption. In an essay. Lapse. Death of beneficiary before the testator. Anti-lapse statute applies to kindred of the testator or the kindred of the testator's surviving, deceased, or former spouse or domestic partner. What does that mean? If I leave $20,000 to my son and he dies before me, the $20,000 goes to his kindred. Sorry, heirs. If I leave that same $20,000 to a friend and the friend dies, since the friend is not kindred, it lapses. The gift lapses back to my estate residuary. Intestate succession, apparently incredibly important. Share of surviving spouse. A, share not passing to surviving spouse. Special problems and simultaneous death. So community and separate property share is what it makes up the share of the surviving spouse. The share not passing the surviving spouse is issue, which is your children, parents issue, etc. Special problems is adoption, stepchildren, advancements, requires writing that lifetime gift is advance payment of intestate share. Right, because if it was under a will, it would be a satisfaction. Simultaneous death. Intestate succession. Intestate succession must prove by clear and convincing evidence that the heir survived the decedent by 120 hours. For testate estate, must prove by clear and convincing evidence beneficiary survived testator. So basically, simultaneous death is treated differently whether you have a will or you don't have a will. If you have a will, you must prove by clear and convincing evidence that the beneficiary survived the testator, which apparently doesn't include the 120-hour rule. However, if it's intestate succession, the 120-hour rule applies. So, second to last part here is the rights of surviving spouse and children. The pretermitted spouse. Spouse omitted from premarital will receives intestate share, which is the community property plus up to half the separate property, unless 1, 2, 3, or 4. 1, omission was intentional as shown in the will. The spouse provided for by transfers outside the will. Spouse made valid agreement waiving right to share in decedent's estate, or the spouse was decedent's care custodian. Their marriage began while spouse provided services or within 90 days after services were last provided, and decedent died less than 6 months after marriage began. Pretermitted children are omitted. Child born or adopted after will executed receives intestate share unless the omission was intentional, as shown in the will, or the testator had other children and left estate to the parent of omitted child, or the testator provided for child by transfers outside the will. Bars to succession include homicide, elder abuse, and a no contest clause. The no contest clause is a will be enforced unless the beneficiary has probable cause to support the contest. All right, so I'll use my own words to explain that. No contest clause means that I write in my will that I'm going to give everything to my cousin and my aunt, and if either of them contest to it, they lose the gift that I said I would give them in the will. Because I don't want my will to be contested after my death. And that's how you would write a no contest clause. For homicide, this is a slayer statute. A person who feloniously and intentionally kills decedent is not entitled to any benefit from decedent's estate by will, trust, intestacy, life insurance, joint tenancy, or otherwise. Some of those are non-probate assets. Elder abuse. A person found liable of clear and convincing evidence of elder abuse will be treated as if he predeceased the decedent, which includes physical abuse, neglect, and fiduciary abuse. The treatment as an intended beneficiary predeceased the decedent. Um, that's the same application that you would apply to a slayer under the slayer statute, and also in a simultaneous death disaster. That's all that's written here in the Will's California overview. Checking to see if there's any, I can read anything else quickly. I may very well be able to read how to answer essay questions. Bear with me while I pull up the PDF. It's not looking like it wants to pull that up. So I'm going to end this here. This recording ends here. Ends now.